Everyone. I am Jason Montgomery, partner in Husch Blackwell's Higher Education Group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for housekeeping items. Let's get started with our program. In this webinar, we will discuss key takeaways from the current NCAA regulatory structure as it relates to NIL, the evolution of college athletics in 2022, and what institutions can expect in the new year. Joining me today is Taronda Randall. Taronda is a senior counsel in our higher education group, and like me, works with colleges and universities on issues related to college athletics. She was also a Division I women's basketball student athlete and has experience both on campus and at the NCAA. Let's jump right in. The direction of college athletics, and this road I think is apropos of what's going on in college athletics. No one's quite certain where things are leading. There might be a light at the end of the tunnel, but it's unclear whether we're going to reach that light. And these are, just some of the issues that are facing the NCAA and college athletics, athletes as employees, ongoing antitrust litigation, conference realignment, a lack of rules enforcement or at least perception, NIL, the transfer portal, although I'm not 100% sure what the transfer portal is, but Taronda tried to explain it to me. Gender equity issues and revenue distribution. These are all things that are really post Alston versus the NCAA, or the NCAA versus Alston. As you all might recall, in June of 2021, the NCAA, in some ways, some would say may have put all of their eggs in that basket of an antitrust case going to the Supreme Court. And the Supreme Court, in a 9-0 opinion, said that certain rules related to education-related benefits violated antitrust law, and generally said that all NCAA rules are going to be adjudicated or viewed under the standard approach to antitrust. There's no longer any sort of special consideration given to college athletics. With that, let's go to the agenda. So today we're going to talk about name, image, and likeness, provide some updates on that, the NCAA transfer committee recommendations, new NCAA rules in Division I, II, and III, changes to the NCAA Division I enforcement model, and the status of ongoing legal matters. To start off with maybe one of my favorite topics, it is name, image, and likeness. And really, when we're talking about name, image, and likeness, we're talking about publicity rights for student athletes. And those publicity rights really relate to earning compensation from third parties. And the concept here was that NCAA rules prior to the adoption of name, image, and likeness, which came about in a clunky manner, in part because of the Alston decision I just mentioned, but really as a result of a series of state laws that put the NCAA on a clock to make changes to their amateurism rules that would allow athletes to profit from their reputation as an athlete. And the concept there, I think, was a worthy goal, was that third parties who are untethered to institutions could now pay athletes for their services in a commercial based upon their notoriety in the community. That was the intent. So prior to the deregulation, which I'll talk about in a minute, athletes, if you were going to be a musician and also a student athlete, you couldn't publicize your music. That's a kind of famous example. There was a wrestler who was also a country singer and was unable to publish a record. You couldn't write a book. Really, you couldn't do anything that was, in some ways, contemplating your notoriety as an athlete. And the concern there was because college athletics is unique in as much as there's a recruiting environment that that was going to drive people to one institution or another, or that boosters would get involved. And we'll talk about booster involvement in what is now known as NIL. So just a quick overview. Probably if you've been on one of these before, have heard me say the last great bipartisan issue in the U.S. Republicans, Democrats, independents can all agree that we hate NCAA rules, and based upon that common theme, state legislators said, "Hey, we can in our state allow for our athletes to be compensated based on their likeness." And really, it started in California. That was the first. It was the Fair Play to Pay Act, or something like that, where California said, we believe that athletes should be able to profit from third parties. We don't think they're employees. We don't think schools should pay them, but they should be able to profit. And they kind of put the NCAA on a clock in 2019 and ultimately passed this legislation. Now, as is the case, other savvy state legislatures around the country said, well, we want our athletes to profit off their likeness too. And by the way, Republicans, Democrats, independents, we all agree we hate the NCAA. So let's also make a rule. And what ended up happening was that Florida essentially put a clock on the NCAA and said that our name, image, and likeness law is going to go into effect in 2021. And that gave the NCAA, it was a little over a year to come up with their own strategy as to how to deal with that. As is the case in many situations, the NCAA formed a blue ribbon commission, spent a year talking about it, came up with a strategy about how they were going to deal with name, image, and likeness, and some guardrails. And then they proceeded to take that strategy and rip it up and throw it in the garbage can and put all of their eggs in the Alston basket. Essentially, they said, we can't really make a determination here on pass this legislation because we have this pending antitrust lawsuit. We're concerned about what the outcome of that is going to be. We believe we're going to get some sort of positive outcome from the Supreme Court in this, and then we'll be able to better craft our own rules. And they were wrong about that. So what ended up happening is, as Alston is progressing, all of these states, or the vast majority of the ones that are on the map as of April 2022, began passing laws, some frantically in the South, where football's more popular, where their athletes, in the event something crazy would happen, would be able to profit off their likeness, so that their colleges could use that in recruiting, and ultimately that the student athletes in their state and their universities would benefit. As was what ended up happening, kind of the rest of the story is Alston decision comes out in June of 2021. Florida's law is getting ready to pass or become effective July 1st. And as a result of that, the NCAA is in a real bind as to what they're going to do. Now, ultimately, what they did do was they deregulated name, image, and likeness rules and said a few things. They said, one, you need to follow your state law. If you have no state law, then you just cannot provide athletes pay for play. So the institution couldn't pay athletes. And you cannot use NIL in recruiting. They can't be induced to come to your school as a result of that. And also, there has to be some sort of quid pro quo arrangement. So there has to be, the athlete has to give something up or perform some sort of service based upon this NIL agreement. So that goes into effect. And many of these state laws, interestingly enough, were premised on the legislation that the NCAA was going to pass, which had some fairly significant restrictions, in particular related to booster involvement. As time progressed, and this map is as of 2022, Since this map has been in effect, New York has joined the club and passed a name, image, and likeness law in January, just this month. So since that time, though, what some states began to realize is our rules, our law that we passed unanimously, again, Republicans, Democrats, Independents, all hate the NCAA. The law that we passed unanimously is too restrictive for us. And so what we started to see, not long after, maybe 6 months or so after the implementation of the rule, was that some states began to revise their state legislation. And Alabama was the first state to altogether repeal their NIL law in favor of what they believed to be the more permissive NCAA NIL interim policy. As I discussed, very simple, follow your state law, no pay for play, no inducements, has to be a quid pro quo. Other states began to also revise their laws, and some of them so that there could be more involvement by institutions in the NIL process. So Tennessee, Illinois, Missouri, New Mexico are all states where they had a law passed July of 2021, and within a year's time period had already revised some portion of that law to allow for additional involvement, primarily of either institutions or boosters themselves. So that kind of leads to NIL with a twist, I like to call it, the rise of the collectives. So when we talk about collectives, what happens is, good intention that laws are passed so that third parties can provide benefits to athletes based upon their reputation. And savvy individuals said, well, we like best those athletes that go to our school. We don't like every athlete, we just like the ones that go to our particular institution. So they started to form collectives. And these collectives were, generally just a group of boosters that got together, contributed money with the concept that we are gathering money that is going to be paid out to athletes for quote unquote name, image, and likeness benefits. What that looks like took many different forms. It continues to take many different forms. That could be a traditional arrangement where someone is actually engaged in representation or advertisement of a product, but more likely it is performing some sort of media activity, appearance, signing autographs, or even engaging in some volunteer work. So these collectives are formed right now. Approximately, it appears there are over 100 that you can identify publicly. So there's about 350 Division I institutions. So, we're talking about a little under a third of Division I institutions all have some type of collective. And if you don't know your collective, you might want to find out who they are and what they're doing. What it really appears to have become, and what the NCAA is most concerned about, is how do we get money from our boosters to the best players and recruits, frankly. There may be some legitimate purposes out there, and certainly some that would comply with NCAA rules and their state laws. But at least the perception out there, and the perception from coaches, in fact, is that we can use these collectives. We need a collective in order to recruit athletes, which is not what the intent of certainly the state laws were, and was not what generally was intended from allowing athletes to profit. It's less about musical talent of athletes and more about their athletics talent. And right, wrong, or indifferent, that's where we're at. So that leads to situations like the most recent situation that came out in January, where allegedly a top quarterback that had signed NLI, National Letter of Intent, with the University of Florida, allegedly was promised $13 million from a collective associated with Florida. $13 million, is that realistic for a high school quarterback? I would just, because the Kansas City Chiefs played Cincinnati Bengals this week. I don't know if you saw that, Taronda.
I'm a Chiefs fan.
Yeah, okay. I looked up Joe Burrow's salary. Joe Burrow makes $9 million on his rookie contract. So whether this was a realistic deal actually happened? We don't know. Was this, mere puffery by the collective? Were coaches involved? These are all questions I think the NCAA likely has. But I don't know if, something like that is ultimately going to lead to an NCAA investigation. We're going to talk here about why it could, and why it could result in problems for the university. I don't know what Joe Burrow made at LSU, but I don't think it was 13 million. That was pre-NIL time period. So what can the NCAA do about things like this? So there's been a lot of media reports about collectives providing, allegedly inducing people to go to a school. Some of it, is it realistic? As I mentioned, the first step is let's look at the interim policy and see what the state law is and whether they're complying with the state law. The NCAA is not going to judge whether someone is compliance with the state law. It's an argument that institutions can make that whatever activity was done was permissible under their state law. So, if you have a more permissible state law, then you may have a situation in your state where the activities could differ from those in surrounding states or other individuals in your conference. But what ended up happening over the course of time, the NCAA came out with some additional guidance. And the first guidance that came out was in May of 2022. And really that related to third-party involvement. And it said, hey, by the way, institutions, just like you were before, you're still responsible for your boosters. And that includes your boosters who are involved in NIL collectives. And that was an attempt by the NCAA Division I Council. So we've now kind of separated. We're no longer talking about all divisions. This is Division I Council saying, hey, we need to do something about these 100 or so plus collectives that are out there, attempting to put some standards in place. And they said, moving forward, everyone is on notice that you're going to be held responsible for the activities of your boosters, including those that are involved in collectives. And then in October of 2022, the NCAA came out with another memorandum. Again, the Division I Council. This was in response to concerns about institutional involvement with NIL collectives. And that memo basically outlined what institutions could do. Again, saying, hey, just a reminder, you can't arrange for NIL activities directly with a particular student athlete. You can't negotiate. What you can do, you can promote NIL collectives that's associated with your school, but you can't have institutional employees that are involved. And really, this can't be looked at as pay for play. Both of those documents are included in the materials for you to review, and it kind of outlines point by point what the NCAA believes is permissible versus impermissible. Then, this is the final step, and we're going to see this play out over the next year. The NCAA adopted a presumption related to the involvement in name, image, and likeness activities in the infraction process. So this was really in response to concerns over the NCAA having the ability to actually prove an inducement, quote unquote, occurred from related to an NIL collective. What the new presumption is, when available information supports that behaviors surrounding and or leading up to an NIL offer or agreement were contrary to NCAA legislation, the infractions process shall presume a violation occurred. So this is the old guilty until proven innocent rule that I'm not sure a majority of you knew was being implemented. To rebut the presumption of a violation, the institution or involved individual can clearly demonstrate with credible and sufficient information that a violation did not occur. So I believe this is tipping the hand that the NCAA does believe they need to take some type of actions on situations, especially those that are public facing, to reassert some credibility in this particular space, and to some extent, reassert some credibility with their own coaches and institutions who are doing their best to follow the policy, to ensure that their booster groups are educated, and to attempt as best they can to navigate this new process. However, there are other pitfalls to NIL, and that includes some concerns related to Title IX. Most recently, just this month, the Drake Group sent a letter to the Office of Civil Rights asking them to essentially suggest or affirm that some activities involving these collectives could be attributed to the institution and result in a Title IX imbalance or violation. Now, traditionally, third-party activities, so if it's traditional third-party engaging with the student athlete in a commercial contract, that would not require, any sort of Title IX evaluation. It really is how far is the institution going to actually facilitate a deal involving an athlete, which would also violate, theoretically, NCAA rules. It's unclear whether there's going to be any statement related to this. What I can say is that, and what we've advised clients, is that Title IX certainly applies in as much as we're talking about treatment areas with the quote-unquote laundry list for athletes. In other words, if you're providing educational or other services related to NIL, you have to provide them equally to both men and women. There could be concerns about promotional activities under the treatment areas related to men's and women's sports, and ensuring that any public publicity is, there's equitable publicity for men's and women's sports. That's probably the closest you could get to a traditional Title IX analysis under NIL or something that would affect NIL. But at least this is an open question, and the Drake Group, which is a third-party advocacy group, decided to put out this statement of this concern. So what is the NCAA going to do? So in addition to the rules that we talked about, there was in August of 2022 a call to action by several commissioners to Senator Tuberville and Senator Manchin about we need federal legislation in this area in order to prevent chaos. Dogs and cats living together, just absolute unadulterated problems. What I think is, so number one, it's difficult to envision Congress, as much as everyone can hate the NCAA, coming together for this on this particular issue in any meaningful time frame that is going to result in some sort of actions. That's number one. Number two, some of these six that are listed, outlawing booster involvement in recruiting, these are all already in place in most state laws and certainly in the NCAA policies. That wouldn't be anything revolutionary. Market rates for NIL activity, again, that was something that was contemplated by the NCAA early on, and there's nothing that would prevent the NCAA from actually doing all of this themselves. Just while I understand the antitrust concerns, certainly that antitrust decision from the Supreme Court in Alston was very limited. Now, I say that, and we're going to talk later on about current litigation and kind of the part three of the antitrust litigation that's playing out again in California courts. So with that, I'm going to turn to Taronda here to talk about transformation. Before I do that, this struck me, and I have this book on my shelf. And so whenever we talk about NCAA transformation, I go back and I look and I say, wow, the executive director, the person who founded the NCAA in 1995, published a book saying exploiting college athletes is what was done, and there needs to be changes and reform to the NCAA. And interestingly enough, kind of like the folks on the Drake Group, not to be offensive in any way, but it's always after they leave the administration or the NCAA, we both can relate to that, although I'm probably more extreme than you. It's always after that happens that there's this publication, and what people said at the time and maybe still say today is, he's old, he's crazy, he's lost his way. And athletics continued business as usual for another 30 years.
Thank you, Jason. So Transformation Committee. And although I didn't interrupt Jason, I gave him free rein to interrupt me as needed. So you may hear from him again. So we're here because the landscape surrounding college athletics is experiencing unprecedented change. And I think people recognize that the NCAA needs to evolve in order to keep up with that change and best serve the student athlete. So the Division I board of directors appoint 21 individuals to lead the modernization efforts after the adoption of the Constitution during the last year, 2022. It was effective in August of 22. There were 3 areas of priority for the committee: elevating support for student athletes surrounding their well-being, so that mental, physical, and academic spaces, enhancing the Division I championship experience, and building an overall better Division I. So the recommendations centered on the decentralization of rules. I'll talk a little bit later about some of the decentralization that occurred related to personnel. And the concern was whether the regulation of rules was occurring on the right level, so whether it was occurring on the campus, the conference, or the national level. One of the recommendations was that the board of directors should review or direct review related to APR. So what's the appropriate benchmark for the academic progress rate? They also want the appropriate bodies to look at the sports sponsorship minimums and the financial aid minimums. Now, championships. So there was some support and referral to the appropriate committees regarding access to championships. The goal is to provide access to about 25% of institutions in good standing. Also want to elevate that travel experience when it comes to primarily to charter travel.
Just one point on that. So this is the big 96 team tournament kind of provision, right? So the transformation committee said, hey, we should get an additional 25% of Division I membership into championships. Now, the big talk was around the basketball tournament, but that applies to all championships that are operated by the NCAA. The question really there, I think, for everyone on that's on this webinar and everyone in Division I is, who are those additional 25%? Where are they going to come from? Are they going to come from the smaller conferences, or are they going to come from what we commonly call the Power 5 or Autonomy 5 conferences? So why that's important? It's because you get units based upon the number of people that go into the men's basketball tournament, which is how revenues distributed from the men's basketball tournament. So is this a case of subtly saying, hey, the haves need to have more and the have-nots be lucky with what you have?
So it's interesting that you mentioned the distribution shares, because they talked about the modification of the revenue distribution program, and they want to look at it beyond just men's basketball, just making sure that it reflects the Division I values. And the committee had a couple points that they wanted to make sure were paid attention to when you look at that revenue distribution program. So 1, what's the implementation timeline? 2, gender equity. I think last year, or maybe it's been a couple years, time is kind of fluid to me now, post-COVID. But the women's basketball tournament kind of brought attention to the inequity among championship experiences, as well as commitment to the broad-based sports sponsorship. So some of the recommendations, and some of these are things that people are already doing. 1, require medical coverage for a minimum of 2 years following graduation or a student athlete completing their athletics experience. Now, the committee recognized that this could cause some budgetary strain, so there may be a need for a national care model regarding that. But again, this is something that a lot of institutions, frankly, are already doing. A commitment to consensus-based care and attestation to certain best practices. So there are a lot of best practices that the NCAA and Sports Science Institute have published. So whether that's cardiac care, the Inter-Association Mental Health Best Practices, independent care, best practices, they're all out there. Those resources are available. And I think, unfortunately, a recent incident in professional sports kind of brought attention to the fact that everyone needs to make sure that their care practices are in line with industry standards, just to make sure that we don't have a catastrophic injury or death. And in the event that there is a catastrophic injury or death, the committee recommends that those circumstances are reviewed within 1 year of that incident. They also want to require funding of degree completion funds within 10 years of separation for student athletes that were on full scholarship. Another thing that they want to do is to extend the protection that's provided to autonomy schools in terms of financial aid, just those 4-year agreements to make sure that student athletes actually have the funds to complete their degree. Attestation regarding provision of academic support services and career counseling services, as well as life skills. So just make sure that you're preparing student athletes for life after sport. Increased participation by student athletes in the decision-making processes on all levels. So from the institutional to the conference to the national level. And that's including student athletes being involved in those ad hoc or special issue committees that sometimes arise on campus or on the conference level. Want to have a direct pathway to full-time clinical services of licensed mental health professionals dedicated to student athletes. Again, this is something that a lot of institutions are already doing. If they don't have full-time clinical services, they're at least providing access cross campus to mental health services. Also, review of physical and mental health safety and performance support services. And Jason, you may have something to add in terms of the work that we're currently seeing regarding that mental health space.
Yeah, so I think a couple of points here. One, as we talk about additional requirements, all of these things cost money. I think it's important to recognize that these are all additional financial commitments that institutions are going to have to make. The second is that traditionally, the NCAA has not reviewed issues related to catastrophic injury. They're not involved in any sort of actual enforcement of particular guidelines or recommendations related to mental health, safety, or performance services. And the question is whether they are ever going to be in that space of enforcing any of those rules that are on the books currently. I don't know if they will. What we have seen is kind of an uptick, obviously, in situations that are not NCAA. Like I said, the NCAA doesn't enforce in this area. They're really not. The rules are there's guidance, but there's not enforceable bylaws in a lot of these situations that are not NCAA violations and not Title IX violations, but are some sort of in between area where it's a coach's conduct issue towards athletes. And the question at that point then is how do you measure that? You're going to look at your institutional policies first, and is there any other good guidance out there? I would suggest to you all, if you do have these issues that come up where you're not quite sure what bucket it fits in, it really is a coach interaction with his team or individual student athlete. There is some good guidance that we have used from Safe Sport. If you all are familiar, that's the U.S. OPC, the Olympic and Paralympic Committee's group that independently evaluates issues related to the performance of non-government entities and the Olympic movement, how coaches are interacting with their athletes. Came about as a result of the gymnastic situation, Larry Nassar, the tragic situation there, and really has focused not only on sexual misconduct involving coaches, but power dynamics and when something crosses a line from hard coaching to abuse. So I would encourage you, if you haven't already, to seek out some guidance in that regard.
And I think the reason we're seeing a lot of that uptick is now, one, the student athlete voice is empowered now more than ever. And two, a lot of institutions are making use of anonymous reporting mechanisms, which is something that I think we recommend a lot of our clients use sometimes when we're looking at issues that have occurred and how it actually came to the attention of the institution. Sometimes it took a while until a group of student athletes, got fed up and brought it to the attention of administration. But a lot of institutions are making use of anonymous reporting mechanisms. Another one of the recommendations has to do with a periodic athletics compliance audit. Previously, that was a legislative requirement. So every 4 years, they had to have someone review the compliance services being provided. And although it was not legislated, it continues to be a best practice. We believe in terms of it's healthy to have someone else that's not involved in the day-to-day look at things and make sure that things are functioning in line with best practices. And they also recommend education be provided to some of the cross-campus partners, some of those people who share the compliance responsibilities. So whether that's financial aid, admissions, registrar, just in recognition that compliance is indeed a shared responsibility. Everyone's on the hook. Want to make sure that appropriate education is being provided to those individuals. So Division II and Division III had similar committees. The Division II had the implementation committee and Division III had the advisory Council, and they also sponsored some recommendations and some legislation related to things such as organizational structure. Now for some of the new rules. So when it comes to Division I, there were some changes made to the undergraduate transfer waiver guidelines and establishment of transfer windows. Jason joked earlier about trying to figure out exactly what the portal is and what it looks like. I think we all can agree that there are a lot of people in there and everyone may not end up with a home, but they wanted to establish some windows just in terms of predictability when student athletes will be leaving, so rosters kind of have an idea of what they'll be dealing with.
Well, just what I think is interesting about this is, again, just my commentary, but it was only some sports that didn't have a one-time transfer exception. So prior to football and basketball and ice hockey and baseball being granted this, maybe softball too, all other sports had the ability to have a one-time transfer exception. And what we've seen now, though, is that all of these other sports, because of, I don't know if this is the publicity of the transfer window, the popularity of it, before this time, they could transfer whenever. Now they have to transfer within windows because coaches in not just football and those sports that the one-time transfer exception is new to, but to all sports are concerned about their roster management. Just strikes me as interesting that the popularity of creating a quote-unquote transfer portal has resulted in the need for additional legislation. You're just feeding the monster. Go ahead.
Sorry. To the credit, some areas are being deregulated, like personnel. So they eliminated the volunteer coach designation, as well as the grad assistant designation in certain sports like FCS, rowing, swimming, and diving. And so that resulted in an increase in terms of countable coaches. They also is legislation that was adopted. Now, granted, it's subject to the rescission period, so it's not yet final. This particular piece isn't. In terms of increasing the number of basketball coaches from 4 to 6. And so the 2 additional coaches would not be permitted to recruit off campus, and they have to meet that IAWP, individual associated with a prospect, legislation. And this is in line with the blanket waiver that has been in effect since last year, that allowed 2 non-coaching staff members to provide instruction. But a similar rule in other sports was defeated. So the rule that was proposed in baseball, softball, and ice hockey was not adopted. There's elimination of the standardized test score requirement and establishment of a minimum GPA. And you'll see later that also occurred in Division II. There's a prohibition of mid-year transfer student athletes, softball student athletes, other than grad transfers, from competing until the next academic year. And again, that kind of goes back to the roster management. And I think the rationale also talked about recognizing the impact that it could have on the student athletes left behind at the prior institution.
Just real quick, for those of you that aren't familiar, IAWP is a term of art that is used in the NCAA manual that basically articulates if you can't hire people who, in order to get a recruit on your team. That's basically what it's trying to prevent. So when you say they can't be associated with prospect, the IAWP legislation applies. That's what it means.
So when it comes to Division II, there are some changes to the organizational structure. There's elimination of the self-study and evaluation requirement, as well as I said earlier, the standardized test score requirement. And this is big. This is why we have it underlined. Now they will allow participation by football student athletes in up to 3 contests in their initial year without use of a season of competition. And that's something that has happened in Division I for a couple of years. They were able to compete in up to 4. They also allow a scrimmage and non-championship segment against a 4-year institution. And there was a change in the first permissible date for basketball practice. So 35 days before the first game, you can start practice. They still have a rule regarding just the 25 days of care that can occur, but no other changes occurred to the bylaw 17 area. They redefined the agent definition to align with the Uniform Athlete Agent Act and also expand a student athlete's ability to seek and receive services and advice. And now they can sell alcohol at Division II championships. More revenue. Division 3, so there were some changes regarding the composition and representation on committees. They granted voting privilege to SAC, so now they have one vote during the business session meeting. There was also the elimination of the institutional and conference self-study guide that no longer has to be submitted. And they adopted a resolution that allowed flexibility regarding mental health hardship waivers. There's some recognition that a lot of times there's difficulty in obtaining kind of that contemporaneous medical documentation if a student athlete suffers from a mental health incident. A lot of times we're seeing that with some of the institutions that we help with waivers, the documentation tends to be lacking. So it's a good thing that there's some flexibility in understanding that you may not always have that documentation that occurred right at the time, but ultimately the student athlete, did take care of whatever issue they were dealing with. There's elimination of the weeks as the measurement for a season. So there's a new playing season structure. There are also some flexibility in the area of recruiting. So now they can have public communication on social media after January 1st of their senior year in high school. All right, Jason, they get to hear you talk a little bit more.
Thanks, Jonda. So I'm going to talk about changes to the enforcement model, and I already mentioned one as it pertains to name, image, and likeness, the presumption, but there's quite a few changes to the enforcement model. And one thing before I get into talking to about the actual changes, I just want to put out there for everyone. So this is probably the third substantive change in the last 10 years to the enforcement model. Back in 2012, 2013 is when the new model that we're currently operating under was implemented. Then you had, in 2019, the independent accountability resolution process that was implemented and some additional changes that were substantive to the bylaws. And now in 2023, we're changing it again. And I would say that 3 substantive changes to an enforcement model in 10 years may cause some concern for member institutions as to what they're operating under, what standards are being applied, and how that could affect your institution. So they called it the modernization of the enforcement model, and I think that's I don't know if it's modernization or we were frustrated that we weren't having enough infractions that were processed, and in part because of what they already had done with changing to a IARP model. But generally, it enhanced the responsibility to cooperate, changed what is known as aggravating mitigating factors to reward cooperation and deter lack of cooperation. Importantly, they changed head coach responsibility. Head coach responsibility used to be a rebuttable presumption that a head coach is responsible for the activities of his assistants and others that occurred in his program. They changed that to just make the head coach responsible. So it's no longer a rebuttable presumption. If there's a violation in your program, your assistant coach does something, you are responsible for that, and then you're going to be penalized. Now, I think what the legislation intends is that the penalty could be mitigated based upon what you had done in order to prevent that from occurring. But it's a strict standard now, strict liability when it comes to a head coach in a program's responsibility in Division I. In addition, with respect to cases, we talk about multiple resolution methods. There always were multiple resolution methods, but now if an institution disagrees with a coach wants to fight a violation, an institution says, no, we agree with the violation, we're done with the case. Now there's more opportunity to bifurcate the case, and the institution can move forward and the coach can argue his position if he deems that appropriate. Clarification of the appeal standard. So with respect to appeals, I think this really is we don't want any appeals standard is what I would say. So you can just cross out appeals in your manual and you might as well not even look at it.
You're so cynical.
Really, there used to be a pretty really robust standard when it came to what was appealable and what that standard was. So now it is for both penalties and for actual factual findings that no reasonable person could have made that decision. And I don't know exactly what that means, but it seems that it's a pretty high bar. No reasonable person. So someone would have to be unreasonable to make a decision. Sometimes people would argue that some of those decisions were unreasonable. But I think this is a really, what's going on here is they want cases to move faster. They want penalties to be implemented. They want to demonstrate, they being the NCAA governance structure, so members of institutions who are on these committees, we need to see some results, and this is one way that they think they can slow down the process. The other thing with appeals is it used to be that on appeal, you stayed the penalties. So it was, if you had a postseason ban, you might appeal that, and that could take you through another postseason, theoretically. Now it's not on an automatic stay. You have to petition in order to stay a particular penalty. So really significant changes to the underlying concepts in the enforcement model. The other, probably most significant change that I identified was the standard of review. So it went from credible and persuasive information to credible and sufficient. And I think that's a lower standard. Sufficient versus persuasive is a lower standard. So what it says is credible, it has to be based on credible and sufficient, direct or circumstantial, so circumstantial applies, on which a reasonable person could rely. So they took out what it used to be was credible and persuasive information that a reasonable person
can rely on in the conduct of
serious matters, yes. Serious affairs. So no longer are these serious affairs; they're just a reasonable person standard. The way I think about this is in real law, which I try to stay away from as much as possible. You have different standards of proof. You have preponderance of an evidence, clear and convincing evidence beyond a reasonable doubt. We are somewhere below preponderance of the evidence with this particular standard that's now in place. I think that the concept, again, is that we can use circumstantial evidence in order to make a case here. We're lowering the bar in order to weed out what is perceived as a lack of enforcement of our rules. In addition, the NCAA is also going to create a public procedural dashboard for its cases, similar to what they did with the independent accountability process, where there is public information available. Obviously, for really since the beginning of the infractions process, most information has been confidential in that process, and I think that has been important for institutions to not be drugged through the scrutiny of what was going on publicly. Now, some of the information is still confidential, but you're going to be known publicly as a case that's ongoing. And I guess the first test of this is, will there be any cases as a result of anything that's out in the media related to NIL? Will that be publicized? We don't know yet. We don't know what the procedural dashboard is going to look like. We can assume it's going to be somewhat like what was done with the independent accountability resolution process. As I mentioned, the presumption of violation in NIL cases. I know a question came in about that. There really is no public information about what the standards are going to be for that. I mean, there is misinformation out there, at least I have found with the clients I've worked with in circumstances where, information is out there that's not even accurate in any way and is certainly just speculation. And it's unclear exactly what the NCAA can utilize in terms of that information in order to make a case. But I would suggest that at a minimum, the information has to be corroborated in some way so that we're not in a situation where we are just relying on, inquirer type stories that are out there in order to punish institutions. And then finally, and sad for all of us in the industry, the discontinuation of the IARP after the remaining cases are adjudicated. And we'll talk about the remaining cases, but RIP, IARP, a lot of acronyms there.
You're particularly proud of that one, aren't you?
The RIP, IARP, yes, I am. But really, again, I think there was some good intent behind this. I think that and in fact, I think many institutions that went through the process might suggest that it was a fair process. It took too long. there was a perception that it wasn't done appropriately, and there was a perception that there wasn't significant enough penalties as a result of that.
And I'll add two things, Jason. One, with the appeals, now it's important to know that it's going to take place on a written record unless the Infractions Appeals Committee decides that an oral argument actually needs to occur. And when it comes to the public information, it's important to remember that institutions do have the ability now to kind of correct the record if something is out there that's inaccurate about the allegations against their institution.
I mentioned IARP cases, and so this is the current status of IARP cases, and I think we can take away from what happened in the IARP impacting what was done in the enforcement model. So of those cases, Memphis, Louisville, and Arizona were the result of the FBI men's basketball investigation. Memphis was a separate matter involving the head coach. All of them involved allegations that of individuals in a program where the head coach theoretically would be responsible. However, in none of those cases were the head coaches actually found to be in violation of head coach control. So I think that has impacted the legislation then being changed to make it a strict liability situation. North Carolina State, the head coach there was found to have violated the head coach responsibility provision. But I think what has happened in the IARP cases has directed certainly what the enforcement model changes were suggested and how they've been implemented or will be implemented.
I think one thing interesting from the Memphis case that stood out to me was that the IRP, that they recognized the fact that the coach was not responsible for the eligibility decisions, because I think there was a little bit of public kind of outcry, the fact that the student athlete was competing in that case, but they recognized that although he did, make the decision related to playing time and personnel, he ultimately was not responsible for eligibility determination.
It's interesting because I don't know, as people who are on campus, are there other people that are really responsible? Do you think? I mean, in most places, the head basketball coach or the head football coach does have some significant authority to push forward their particular agenda. So, I mean, I think that's an interesting point, and believe me, I like it. But I don't know if it's factually accurate in all situations.
Well, the institution would be in a world of trouble if the head coach was certified eligibility and having the final say.
Well, I'm not saying certifying. I'm saying, hey, we need this guy to play. But yeah, I see what you're saying. So those were the IARP cases, the kind of higher profile situations. These are the Division I infractions cases over the last year. 5 published cases versus 19 average. I think this, my guess, and just based upon my own experience, is this doesn't reflect a lack of what the enforcement staff is doing. It really is a transitional time period. There was probably more emphasis placed on the IRP cases and getting those finalized. But as you can see, the issues, COVID-19 dead period was a significant issue. But other than that, you don't see really a significant recruiting or NIL case that has come out yet. And I don't think we're going to see one, for a little bit longer, certainly. Anything else on that, Sharonda?
No, but I will note, in the interest of time, that you have about 8 minutes to talk about the legal matters that are kind of pending.
I'll be efficient. Thank you. All right, moving on to ongoing legal matters, and obviously this affects not only Division I institutions, but I do think that it affects all collegiate institutions as to how they're going to interact with their athletes. The first issue is what I talked about is the next act in the antitrust trilogy, and that's House versus the NCAA. Again, this is in the same trial court as O'Bannon and Alston. So if we think about what these different cases are about, O'Bannon was really about what an institution can provide to an athlete and what the institution can do with a likeness in exchange, what's sufficient. O'Bannon said, you can give up to an athlete additional cost of attendance stipend, and that's kind of sufficient in order to meet the requirement of a less restrictive means for the particular collegiate athletics enterprise. With Alston, it was really about a limited group of education-related benefits. With Alston, what was interesting is that in addition to kind of the traditional education-related benefits, the court crafted I guess, an additional payment process for academic-related benefits, which have now become known as Alston payments. But basically, it says that in the NCAA rulebook, you can receive up to a little bit over 5,980 total in athletics benefits, separate from your scholarship, separate from cost of attendance. So there's a section in the NCAA manual. It lists out, trophies and different scholarships that athletes can receive, different based upon their participation in athletics. And the court in Alston said, let's add all of those up, and you should be able to also give that same amount to athletes for academic-related benefits. So you've seen a significant number of institutions implement Alston benefits based upon academic performance. It's also an example, I bring this up because it's an example of not wanting the courts to make your rules for you. In O'Bannon, the decision by the trial court judge was that athletes should be able to receive cost of attendance plus $5,000. That was appealed to the Ninth Circuit, and the $5,000 was struck. And the Ninth Circuit said up to cost of attendance is sufficient compensation to be provided to athletes in this situation. In Alston, same court, and there's $5,980 additionally that can be provided to athletes. I don't think that's necessarily an accident, but it's an example of why you don't want the courts deciding the mechanism that you are operating under as a collegiate enterprise. In this most recent iteration in House, the plaintiffs are really alleging issues related to their use of their name, image, and likeness, and the fact that they had not been able to profit from their name, image, and likeness prior to July of 2021. The date of the case goes back to 2016, but it also alleges that in football and basketball, the athletes should have been allowed to share in the profits from the television contracts, which is a whole new concept altogether. Where are we at with this case? So we're at the certification of class status. So the last filing was a class status request by the plaintiffs for 4 classes. The first was an injunctive class from June of 2020 forward that essentially says that athletes in football and men's basketball, and just for to be clear, we're talking about NCAA Division I football, men's basketball, Power and the Power 5 conferences. That's who was named, the NCAA and the Power 5 conferences. That those individuals should be able to share in the benefits of the television contracts that are currently negotiated between the NCAA and media outlets and the conferences and media outlets related to football. It would be a significant change, and certainly be unclear how that injunction would apply. There's also 3 damages classes, one related to football and men's basketball, one to women's basketball, one to all sports. The football and men's basketball also, from the past, beginning in 2016 up to the class certification, would include this television sharing concept in addition to NIL. Women's basketball and all sports are NIL. That is pending the response from the defendants is due in April, and then it's not set for a hearing until July. So we're really not going to know the outcome of the class certification until late this summer or early fall, and it's not set for trial until January 2024. I think realistically, if there was a situation where the NCAA lost, or really either side, we're looking at probably 2027 or beyond before there's a final resolution, with the concept that I think the plaintiffs certainly want with the Alston decision out there, want to go to the Supreme Court. College athletes as employees, and now I have 1 minute, right? So
I tried to tell you. You seldom listen to me.
Okay, real quickly, 2 big concepts here. One, the NLRB, National Labor Relations Board, there's an action filed in California related to USC, and also, interestingly enough, saying that the NCAA and Pac-12 conference could also fall under the National Labor Relations Act because they have private entities that are part of their conference. So that's pending out in California. And then lastly, the Fair Labor Standards Act in the Third Circuit. The judge in this case initially said that there was a claim that athletes could be employees. That is up to the Third Circuit on an interlocutory appeal, and will be decided only whether athletes could be deemed employees under FLSA, not the underlying facts of the case. So we're a little bit over time. A few points that to leave you on a high note because I was kind of negative today. Hope springs eternal.
Jaded Jason.
First of all, the NCAA has taken some actions. They reset. They have a new constitution. There is the Transformation Committee recommendations. There's a new president, Charlie Baker, new president of the NCAA. I don't think anyone would disagree that that's a step in the right direction. Toronto, would you disagree with that? Charlie Baker's a former governor of Massachusetts, will take over the presidency in March of the NCAA. The other couple important points is there was an unwillingness by the majority of the Supreme Court to get into the pay-for-play argument. They intentionally said we are deciding a narrow issue. We're not deciding whether athletes should be paid, for their participation in intercollegiate athletics. And then regardless, the games are still going to be played, and they're going to be compelling, and people are going to enjoy college sports for some time to come. So with that, I appreciate y'all's time. We didn't have a chance to get to questions. We will take a look at those and respond to individuals, individually, and really appreciate the time. And Sharonda, appreciate your presentation as well.
Thanks for having me, Jason.
Thank you.